Welcome to episode 46 on the law rapport. Today we are going to look at the defense of self-defense in criminal cases. But before I do, my usual disclaimer: this is not a legal advice, should not be construed as such. For legal advice, please contact an attorney of your choice. I'll be back shortly to discuss this topic. Self-defense is a common law defense. The defense is available to crimes committed by use of force. The basic principles of self-defense are set out in the case of the Queen and Palmer of 1971 and were approved in the case of the Queen and McInnes, when the court said that it is both good law and good sense that a man who is attacked may defend himself. It is both good law and good sense that he may do so only what is reasonably necessary. So a person, in essence, may use such force as is reasonable in the circumstances, in the prevention of a crime, in effecting or assisting in an unlawful arrest, or in defense of another person, in defense of property, or in the prevention of a crime. In assessing the reasonableness of the force used, the court would look at two factors. One, was the use of the force necessary in the circumstances? That is, was there a need for any force at all? And two, was the force used reasonable in the circumstances? The courts have indicated that both questions are to be answered on the basis of facts as the accused honestly believed them to be at the time. This was established in the case of Queen and Williams and the Queen and Hartbridge. So in essence, it is a subjective and objective test. A jury must ask themselves whether on the basis of the facts presented to them that the accused believe that he was in imminent danger of being attacked, or while being attacked, the force used was necessary. That would be a subjective test. The objective test would be a reasonable person, having regard to the circumstances and the force used, would ask themselves if the force was reasonable or if it was excessive. It is important to bear in mind that when assessing whether the force used was reasonable, regard ought to be had to the words of Lord Morris in Palmer and the Queen of 1971, when he said, if there has been an attack so that self-defense is reasonably necessary, it will be recognized that the person defending himself cannot weigh to a nicety the exact measure of his defensive action. If the jury thought that in a moment of unexpected anguish, the person attacked had only done what he honestly and instinctively thought necessary, that would be the most potent evidence that only reasonable defensive action has been taken. The fact that an act was considered necessary does not mean that the resulting action was reasonable. It could be excessive or the force could be unreasonable. That was established in the case of the Queen and Clegg of 1995, where it is alleged that the person acted to defend himself or herself from violence. The extent to which the action necessary was taken will, of course, be integral to the reasonableness of the force used. In the case of the Queen and O'Grady, it was held by the Court of Appeal that the defendant was not entitled to rely so far as self-defense is concerned upon a mistake of fact which had been induced by voluntary intoxication. So if a person is intoxicated voluntarily, not that his drink was spiked or some other form of involuntary intoxication, and he perceived facts and were mistaken about those facts. For example, that he was under imminent attack, or a person was about to attack him, etc. And he used force to repel an attack that wasn't imminent or was ongoing, then he cannot rely on this mistake of fact. So the key takeaway or takeaways in the case of self-defense is that the attack must be imminent, the force must be necessary, the force must be reasonable, and that any excessive force could lead to a defense of self-defense being hard or a failure to establish the defense. Here is where I will leave it for today. I hope that you gathered something from this episode, and if you do, please leave a comment in the comment section down below. And I will see you in another episode.